Hello, 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 hello. Okay, so this is going to be a law school classroom. You're going to enjoy this one because this is going to get into some nitty gritty stuff. I teach this to my students. It's actually like an entire hour and a half long lesson on contract law as it relates to the purchase and sale contract. Now, remember last time we were on, we did a review of the letter of intent. And the letter of intent now flows very nicely into the purchase and sale contract. Now, I recommend all my students have use my template for purchase and sale. And what I tell them is you always need local counsel to review your purchase and sale contract because my purchase and sale contract is not valid in all 50 states. So you've got to go see a local counsel who's going to give it your blessing. Now, my purchase and sale contract has been developed over 20 years of being in this business. And I'm going to show you some of the get out of free jail card provisions in there that enable you to protect yourself and protect your earnest money deposit in the event that things go wrong, as they often do. All right, so first off, let's get started here. I'm going to first off make sure that I'm being viewed live here. Yep. Okay. Let me go blow this up a little bit more, just so you can see it better. Bada boom. Yeah. Okay. So obviously, here we go. This is a preamble, Article 1. Probably blop that down a little bit. Now, first article, sale and purchase. Now, remember, the thing about a multifamily acquisition is you're not buying real estate. You're buying a business. You're buying the whole enchilada. You're a very holistic approach here. You're not just buying real estate. So, the most important asset that you're buying are actually contracts. You're buying the lease contracts because nothing happens in a multifamily deal until somebody writes a check and signs a contract. And the first contract that generates any revenue is going to be the lease contract. So that's what you're buying, and that's why you've got to make sure that any type of purchase and sale contract, and I recommend you get your own. Use your own purchase and sale contract. Use the contract that you are most comfortable with, and one that, in the event of trouble, where all the escape clauses are, because it's your contract. If you're going to be in this business, don't let some broker string you along with their template document, because of the number one rule. The number one rule, and my students know it cold, is always remain in control of the deal. And there's no better way to remain in control of the deal by understanding the terms and conditions within the purchase and sale contract and know how to influence them or when they need to be influenced. Okay. So as you can see here, we're calling it the project. And the project is made up of land, improvements. Now, right there's your real estate. There's your real estate. But the project doesn't stop there. It also includes personal property, all the things that aren't nailed down. It includes the contracts, which are what you're really buying. And then it includes any type of intangible property that comes with the deal. And any service contracts, because those service contracts are an asset. I'm just doing a deal right now, and I just found out that the laundry contract is actually about to terminate. It's going to terminate in about 6 months. I'm very, very happy about that, because if you know these contracts, you know what happens when these long-term leases terminate. You get to renew them, and you get to renegotiate them, and you get a big fat check. All right, so there it is: the land, improvements, personal property, tenant leases, intangible property, and the service contracts, all called the project. Okay. Then we get into the purchase price, and we talk about any way that how the purchase price comes about. And remember, if you had anything in the letter of intent that modified the purchase price or how it's going to be done, it would appear in here. For instance, seller financing. Seller financing that was discussed in the letter of intent would appear here. That's how it happens. All right. Earnest money. Obviously, the earnest money deposits that are discussed in the letter of intent will be put in here. Now, in this particular case, we're doing the earnest money deposit and then the second earnest money deposit. So sometimes in order to get your offer to rise to the top of the competition, you might need to get a little creative and make yourself stand apart. So you might end up doing things like maybe 2 deposits, a deposit now, and then a second deposit when the property property passes due diligence, and that might be one way of doing this. Let's see. Let me see. Shall we apply to the purchase price at closing? All right. And then the escrow agent. Remember, there are actually 3 parties to a purchase and sale contract. You got the buyer and the seller, and then you're obligating the person who's holding the money to certain terms and conditions. So they've got to be bound by this contract. They have to agree to the terms and conditions of the contract. Okay. Article 5, survey and title matters. Now, in the letter of intent, that's the first time we tell the seller we want their survey. Within 15 days after the execution date, and to the extent seller has it in his possession, seller shall deliver to buyer a survey. Okay, so we put in there a seller has it in his possession. That's what we really want to get our hands on. As a matter of fact, I've got to do that on the deal that I'm working on with one of my students right now. We've got to get our hands on that survey, and that the reason for that is really it saves us money and it makes the title insurance policy less restrictive, because if we can show a survey, the title insurance company will remove certain exceptions to the policy and we can get a much more all-encompassing title insurance contract. Okay. Then we talk about the title commitment. Now, remember, folks, I talk about the 3 phases of due diligence. First, 1, financial, physical, and legal. The legal due diligence is essentially the whole entire title commitment policy. All right. So what that means is when you sign on the dotted line, the seller is responsible for going to get a title insurance commitment letter and sending it to you. And when you receive it in the mail, email, you are not going to sit on that contract. You're going to get it to your local counsel and ask him to handle the title commitment exception letter. All right. Because as what you'll see here is there are going to be exceptions on the contract. Well, you don't want exceptions on the contract. You want, you want to get those removed. And so you're going to have your attorney, your local counsel, get in there and try to remove as many as possible. If you have the survey, you get a lot of them removed. If you don't have the survey, they stay. So what we're trying to do is take it from an insurance policy where the insurance company can say no a lot of times, and we want to get it to an insurance contract where the insurance company doesn't say no many times. That sounds crazy, right? But that's essentially what's going on in this title commitment process. It's really like, can you imagine buying a life insurance policy that doesn't pay upon the event of the person's death? It's going to be the craziest thing. Well, think about the title commitment, the title insurance policy, and the exceptions to the title policy as a way for them to get out of paying a life insurance claim upon the time of death. All right. So, and listen, this is a very, very important part of the contract. You don't want to fly past this. You don't want to make any mistakes. You really want to have someone that knows what they're doing to take a look at it and make sure that you're getting everything taken care of. Because remember, for most of you, this is not your money. You're using somebody else's money to make this deal happen. Make sure you cross your T's and dot your I's. And it starts with this. Now we get into Article 6. Now, in the letter of intent, there was a Schedule 1. That Schedule 1 listed all the due diligence requirements that we want from the seller. The seller had every opportunity during the LOI process to go through the list, and cross out things that they don't like. If they can, I'll tell you, if I get a letter of intent signed back from someone, and there is not one mark on the Schedule 1, I know we're in for some trouble. And here's why. What we're going to do is take that whole list, the Schedule 1, copy and paste it right in here. And therefore, we're taking what we agreed to in the LOI and we're putting it into the purchase and sale contract. And this is where it gets nutty. This is where the seller comes back and goes, oh, I'm not going to agree to that. I'm not going to agree to that. I don't agree with that. Well, why didn't you say it back when we're doing the LOI? You could have just as easily told me then that you didn't have this stuff. Why are you telling me now? According to the LOI, you've already agreed to this. But then you have to go back and you have to negotiate it because the guy didn't read it. And listen, I know this is how it works. This is how it goes. Now, here's the one thing. I go, let me see. Where's the, let me see. He says, well, where the heck is it? Oh, man. Hold on. This is interesting. Hold on. I got to find this because I pulled this out from one of my students. They might have modified it. But the most important thing is the last 12 months of bank statements. Let me see. Phase 1 cut to the extent that these covered the most guy. No, boy, that one got cut. Oh, that one would not pass. JK. It's usually K. They may have agreed to it. They may have had this removed, but you always have in there the last 3 months of the last 12 months of the bank statements, because what happens in that case is it's your job is to go back in there and make sure the property is what they say it is. And so you're going to go back and rebuild the financial model over the last 12 months. Well, the only way you can start doing that is at the very top. And the very top of any trailing 12 is the amount of money that was collected or came in. And the only way we can verify that from a third person is by getting the bank statements and matching them up. And that's how we do it. And if they give you the baloney line that I see so often, which is, oh, well, we have more than one property and we commingle all the funds. Yeah, baloney you do. There's no way, if this isn't a standalone property, an LLC on its own, there's no way that you cannot separate the cash coming in from one property to the other. I want to see what you send your accountant who signs off on the K1s every year, because that's the way it has to be done. Otherwise, you're a liar. All right. Operation and maintenance of maintenance prior to closing. This is very important. You want to always make sure that they're going to continue to maintain that property just as it was done before. Let me see if I can find some of the get out of free jail cards. Let me see all that. Free and clear of any such element. Okay. We put things in here like until the closing. Seller shall not sign a new lease or renewal for a period longer than 12 months for an amount less than the stated market rent. That's why they don't want to start putting their family into the units at half price. Okay, so here's the inspection period. Now, this is really cool. Watch this. This is how we do it. If buyer notifies seller before the expiration of the 30-day calendar period, commencement on the execution that buyer for any reason whatsoever does not desire to consummate the transaction, then the money comes right back. Hold on, where am I? Okay. Prior to God. Okay, so this is a 30-day window. Oh man, I grabbed a really old one. Here's the financing period. Now, check out how we took care of the financing period. We put in specifics, very specific terms within the debt. 70% LTV, 25-year AM, 5-year term loan commitment. And a lot of this stuff, I typically leave this wide open. What seems to have happened is I grabbed a client's purchase and sale contract where they had negotiated different terms than we typically do. This is not the standard document that I give to my students. Let me see if I can find. Hold on. Let me see. Let me see what this is. Let me see. All right, hold on. Let me stop the share. Let me try to do it again. I'm going to find these documents for you. Present, share screen. All right, let me see if I can pull these things out again for you. Okay, apartment complex. Where is permanent purchase? Oh, let me go right down to Article 6 and see if it's in here. This is embarrassing. H-I J. There we are, folks. I knew it right there. Certified copies of the last 12 months of monthly itemized bank statements regarding operations at the property. Yes, most important one. And there it is. We always stick it in the bottom. Don't ever let them bamboozle. Say, oh, those don't exist. Yeah, of course they exist. Let me see. Okay, here's a good one right here. Not without buyer's written consent, enter into any written or oral service contracts or other agreements with respect to the project. Remember I told you that my contract's going to run out in 6 months. I've taken over properties where the contract had run out, and then this guy went out and signed a new laundry lease, and he kept the money. I said, no. That's not how that works. All right, let me see. Okay, so check out this one. I put this in here. Until the closing, the seller shall not sign a new lease or renewal for a period longer than 12 months for any amount less than the stated market rent. Should a change in occupancy, which is greater than 5%, seller shall notify buyer immediately, in which event the buyer shall have the option to terminate this agreement and receive a return of the earnest money. At no time shall security deposits be applied to rent or any other fees or charges due from resident. No lease shall be executed without a fully completed and signed application, credit report, and no concessions will be given for rent or deposits. Okay. Every clause in that paragraph is in there because of a seller trying to pull a fast one. I mean, especially the one about using security deposits. Make sure you have this type of wording in your contract. Here's another great one. And this one came about because the seller was trying to pull a fast one. Check this one out. All appliances, fixtures, and equipment relating to plumbing, heating, cooling, blah, 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 and others shall be in normal working order at closing. You have a down unit? Well, guess what? I'm not paying for it. Ordinary wear and tear accepted. No fixtures or appliances shall be removed from the property after the effective date herein without notice to buyer. All units shall be in rent-ready condition at the time of closing unless otherwise specified herein or unless vacated within 48 hours prior to closing. Any units vacated within 48 hours prior to closing shall be reported to the buyer prior to the closing. So these are all conditions subsequent, conditions precedent that have to be taken care of before you buy this property. If not every unit is owned as operational, well, they've got to fix that. You're buying a 150 unit property, not a 146 unit property. So their responsibility is to bring that unit up to code. And if they don't, well, guess what? You're not paying for it. There's going to be some negotiation. All right. And one of the reasons is, let me just tell you, I see this so often. When a seller buys a property and the property just takes forever to close. Well, that guy checked out of that deal long ago. He can't wait to get that check. So he has not been running that property the way it's supposed to be run. That occupancy is probably dropping down. And that's why we've got that 5% provision in there. And having that 5% provision in there and this particular wording right here, that means the guy's got to run this property. All said vacated units shall be in rentable condition with the exception of normal cleaning requirements or appropriate adjustments shall be made to place the units in rentable condition, like money. That's where you get a credit at closing because he's got so many down units. Here's the inspection period. Now, let me see. Okay. Okay, so check this part out. This part I want you to see. And this is one that came about over time as well. And what happened during this time was that we would get under contract. The seller would have a certain amount of time to give us all the documents. They would drag their feet. Our 30-day window got shorter and shorter and shorter, and we could never tell whether we should do the deal or not. So what we decided to do is modify our contracts in such a way that let me see if I get this done. We could do it in such a way that the clock did not start ticking until the seller gave us all the documents. So I think it says it right here. If buyer notifies seller in writing before the expiration of the 30-day calendar period, inspection period, commencing upon the receipt of all documents and requirements detailed, remember section 601? And we're calling that date the effective date. The effective date is a floating date. It's never use a date certain in a contract because it takes forever to negotiate these things. If you miss a date, you've just screwed yourself. So in this particular case, the effective date of the contract is when the seller gives us all the information we asked for back when we first sent out a letter of intent. So if he says, well, I didn't know. Well, dude, I told you 2 months ago. Give me all that stuff. And says, well, it's going to take me time to get you all that information. Dude, I've been waiting for you. Did you not know we were going to sign this? Have you not been reading it? Get me all that information. I'm not going to write an earnest money deposit check until all that stuff is it. And let me go back here for a second, just so you can see it. We go back up here to the earnest money. Earnest money within 7 business days after the effective date. You don't have to stroke a check in this deal until he has given you all the information you need. Same with the financing period, 45 days from the effective date. All right. So these are the things that they float, and it's contingent upon the seller giving you everything they need. Now, folks, there is absolutely no reason why the effective date cannot be the execution date of the contract. No reason. The only reason it isn't is because the seller hasn't done his job. Okay, so that is crucial, absolutely crucial, and it saves you from getting into a bad deal. And then we put in a finance extension period. I'm not going to go into the environmentals, inspection by buyer, casualty or condemnation. Casualty is if there's any type of insurance claim on the property. That's always a fun one. Make sure this provision is in there because it happens. It happens. And you've got to figure out a way that you're going to be protected in the event that it does happen. Condemnation is if this government comes in and condemns your property. Now, folks, condemnation doesn't mean that your mother is a bad housekeeper or anything. The house I grew up in was condemned. I love saying that. My mother always hated it when I said that. But it was condemned because the state took it through eminent domain. That's a form of condemnation. All right, so just don't get afraid, but that's what this means. And what they're saying is, hey, if while we're under contract, the state comes in and takes it through condemnation, whatever type, well, we're going to have some talk. We're going to figure out what we're going to do next, but it's in the contract. Representations. Okay, here's the deal. You're going to see sellers' representations and buyers' reps. This is where your local counsel proves his weight, his mettle, because they are going to make sure that any reps that you are responsible for don't hurt you at some point in the future. These two provisions, the reps, warranties, reps, these two sections on sellers' representations, buyers' representations are so incredibly important. Whenever you see the wording like this will survive the closing date, that's a red flag for you. That means that you need to understand that after the closing, I'm still on the hook for something. So you want to make sure you always understand that and have your lawyer do a bang up job and make sure that he's representing you correctly by making sure that he's protected you in these situations. Flood, purchase options, notice of violations or defects. These are all the things that you need to understand. These paragraphs are the ones that everybody glosses over, and you shouldn't. You absolutely shouldn't. These are so incredibly important. Survival of reps and warranties. The reps and warranties set forth in Article 11, made as of the execution date, are remade as of the closing date and shall not be deemed to be merged onto or waived by the instruments of closing, but shall survive the closing. And the question becomes, how long do they survive the closing? 6 months, 3 months, 6 months, 12 months, 2 years? That's where you really need to protect yourself. I'm not kidding you, folks. This is where I've seen deals where buyers that didn't know what they were doing just screwed themselves over because they did not understand what they were signing. Closing. Let's see. Obviously, the closing, this is what we're talking, what the seller has to deliver, what the buyer has to deliver, and these things you want to make sure ahead of time. I'm actually involved. We got 30 days before we close on a new property. And so I've already gone through our section in the purchase and sale contract to review exactly what needs to happen, and that we're going to have everything taken care of before the closing. All right. And that is, what you're going to see. I'm going to take you to Article 15, Section 15. Real estate commissions. You always want to make sure this is in here. And this should tie in directly from what the letter of intent already said. Remedies of default. What happens in the event of breach on the part of the seller or the buyer? Now, typically with the seller, if the seller defaults, there are two types of remedies. Number one is they can seek what's called specific performance, and that way the seller will sue the buyer. The buyer's sole and exclusive remedy. So the seller defaults, the buyer can go out and sue the seller and force him to sell us the property. That's called specific performance. The other one is terminate the agreement and receive a full refund of the earnest money. All right, now here's the key. It's one or the other. Make sure you understand that. Make sure when you're writing this contract, you put the right conjunction in there. Now, with the buyer, typically the only remedy is he keeps the earnest money. As you can see here, the sole and exclusive remedy is to keep the earnest money. That's it. Because, you're not going to make the buyer buy the property because he probably can't. Can't get a loan. Can't qualify. Property can't qualify. So you're not going to force the guy to buy something that he can't buy. But you are going to take his earnest money deposit. I actually was involved in one case where I actually had the property. I sold the property, and the person breached 5 days before the close. They said, okay, you know what? We are going to not buy the property. Well, we got a $10,000 earnest money deposit. Yeah, we're kind of hoping you would give it to us because you're a good guy. I said, why aren't you buying the property? Well, because my mother, who wants the property, she's getting cold feet. I said, no, your mother's cold feet shouldn't be my problem. And I got a whole another 2 to 3 months to go through this again that you guys screwed me over. So no, I'm keeping your money. So that's an example of what happens when the seller defaults and you keep the money. All right. So miscellaneous notices. You're going to have all your information, your attorney's information right here. Successors and assigns. You always want to make sure that you can assign the contract, okay? Oh, hold on. I lost myself here. You always want to make sure that you can assign the contract. Don't get into a contract where it says subject to permitted assigns as approved by the seller. You don't want to do that. Buyer may have freely assigned its rights hereunder to any affiliated party without the prior written consent of the seller. Okay. Memorandum of contract. They don't want, this is called the recordation provision. Buyer may prepare and record a memorandum of this agreement at its sole cost. Okay. So let me explain to you what this means. When you sign these contracts, and the reason why they keep telling you, if you're dealing with a lawyer, if you're signing this contract, you should have a lawyer who's going to tell you, whether you got a good deal or not. But when you buy this property, you sign on this contract, you have now created an interest in land. And because you've created an interest in land, you can march yourself down to the registry of deeds and record this interest in land. Even though it's a purchase and sale contract, you can still record it. So what this is saying here is that the buyer can go down and record this contract. Well, the reason why the buyer would do that is to cloud the title. So the seller can't go behind his back and sell it to somebody else. Okay. The seller is the one that would say, no, I don't want you having the ability to record this contract. No recordation. And therefore, it's just between us. You can't go out and tell anybody, or you can tell them, but you can't record it to the world. So don't do it. And that's what that memorandum of contract, because what you're going to do is you're not going to necessarily record the contract. You're going to record a one-page document called a memorandum of contract that basically says that this is a memorandum of contract. These two parties have entered into a purchase and sale agreement dated such and such a date, and we're letting the world know that this exists. So now anybody that comes to try to buy that property now has to deal with that cloud on the title. Okay. Let's see. State or Commonwealth, the governing laws, we usually use the one where the property is located. Time is of the, let me see, total agreement. This is a great one. And this goes back to what I was saying about the letter of intent. If it's in the letter of intent, but it doesn't get transferred over to the purchase and sale contract, it's like it never existed. And the reason why that is strictly because of the total agreement. This is also called the merger clause. It says this agreement constitutes the entire agreement among the parties pertaining to the subject matter hereof, and supersedes all prior and contemporaneous agreements, like a letter of intent. No representation, warranty, covenant, agreement, or condition not expressed in this agreement shall be binding upon the parties hereto, or shall have effect or be effective to interpret, change, or restrict the provisions of this contract. You probably heard the term that it's within the four corners of this contract. If it's not within the four corners, it doesn't exist. If whatever happens or whatever you guys put in there is not valid, then we just take out that one part. The rest of the contract is still valid. You can sign it in counterpart. Listen, in commercial deals, they're always signed in counterpart. Effective date. Now, check this out. This is very, very, very important. I specifically put in each contract wording that describes and details and defines the effective date versus the execution date. Those are two entirely separate dates, and they do entirely separate things. Make sure you understand this, because remember, you use the contract that you're comfortable with, and you're going to need to know how it works in the event of something. You asked me a question about my student's purchase and sale contract. I know it cold. So that's why you see these two different definitions. And then this right here is called the COVID clause, force majeure. That's like acts of God. I'm not going to go through this because hopefully we'll never have to deal with this again. But that's what we did. Okay, so then we put it all in here. Now, keep in mind, I'm not going to go through each one, but within this contract, we have referenced 5 exhibits, actually 4. Exhibit E we're reserving for whatever else. Let me just run through what these are. Exhibit A is the land. We want to see the definition of the land as it's recorded in the registry of deeds. So we go capture that. It's essentially a cut and paste from what we find online, and we paste it into Exhibit A, and that defines the land that we're buying. Okay. Now, here's what a good lawyer does is he goes in and he reads that land definition and he makes sure that it is accurate. I had I had this one property that I bought, and my lawyer put the definition into the contract, and then he read it. And in this particular case, it was down in Texas. So the way it works in Texas, it's one of those things where they start the definition of the surveying of the land at one set point, and then they go out, 45.2 meters or feet or whatever it is, and then we turn northwest X degrees for another 27 meters. And then it turns this way. And so what happens is, by the definition that you see in there, it defines the land. And as you go around the number of degrees, because it brings you back to that central point, all of those degrees should add up to 360. And it didn't. And it was not a closed, defined land. So we had to draft a new deed and define the land for it. Okay, so that's one thing. Now, Exhibit B is the deed. Now, you have to understand, and this is typically goes into the purchase and sale contract, as to what type of deed the seller has and what type of deed he's bestowing upon you. See, every state has different types, not everyone, but states differ in the types of deeds: quick claim deed, warranty deed, special warranty deed, general warranty deed, all these different types of deeds. Now, each one has different restrictions. If you got a special warranty deed, you can't turn around and bestow on someone else a general warranty deed, because you don't have that right. But if you have a general warranty deed, you can turn around and bestow a special warranty deed on someone. It's a lesser deed. So you can't give them more than what they have. So that's why it's very important for you to understand what type of deed the person currently has. And then the Exhibit B shows what type of deed you're going to be giving them at the closing table. And that's where you want to make sure your lawyer reviews that and make sure it's all okay. Assignment and assumption of leases. This is where they're going to bestow upon you all the leases, all those contracts that are sitting in the management office. They're going to assign it to you. You're going to assume those leases. Bill of sale and assignment, that's when you're dealing with all personal property. You're going to have this bill of sale completed with listing out all the personal property for Exhibit D, and that is it. Once you do that, you now have exactly what the purchase and sale contract should look like. I'll tell you right now, I'm drafting an amendment to a purchase and sale contract for some clients of mine. And because we've got to get the deal back moving, we both sides have said, okay, we agree that didn't work out, so we're going to change it this way. So I'm right now drafting the amendment to the purchase and sale contract, and we'll get that deal back under contract. But that's how it works. That's how it works. It's you can't blame anyone else but yourself if you don't know what your purchase and sale contract says for the deal that you're doing. So make sure that you do. My students, they got an hour and a half long video where I teach them every single paragraph in the provision so that they know exactly how it works. I give them examples. I teach them through stories that have transpired with the deals that I've done. That's it. That's it. So that's it went a little long today. That's fine. If anybody has any questions, shout them on out, shoot them on out. But that's the deal. Thank you so much for this. I hope I see you on Thursday. I got a lot going on Thursday because I got all these deals closing, all these deals going on. It's fantastic because my students are investors. And when you're an investor, you find deals. And right now, because everyone's running away, we're finding some pretty good deals. So, all right, check it out. Let's make it happen. I will talk to you on Thursday, same bat time. Talk to y'all later. See ya.